like to introduce Mrs. Daniella Vitagliano. I hope that I pronounced the name correctly. Public defender from Brazil. I'm very excited and interesting to hear your experience.
So in first place, I would like to greet all my colleagues and say that it's an honor to be here and share all these experiences and ideas that will sure enrich our work when we go back to our countries. Nowadays, I'm the coordinator of some programs of access to justice and strategic litigation in the Public Defender's Office in Rio de Janeiro, Brazil. And today I would like to share with you an interesting experience that we are developing in Rio regarding the raise of the persons in prison who don't have a birth certificate. What stops them from to exercise the full rights from the citizenship. That's one of the foundations of our republic. It's important to mention that we are a little more than 800 public defenders in Rio, and we are responsible for civil matters, criminal matters, and family, and every issue for all the poor and vulnerable people who come to us. Although Rio is one of the richest states in Brazil, we face a high rate of poverty, and our public is very, very large. Thousands of detainees in Rio have no formal registration and consequently no ID. This situation leads them to invisibility because they don't exist towards the state. Having no ID means not being a citizen. One can vote, can study, can't reach healthcare system, can't have a work permit, and after they leave prison, after they get released, their situation is as worse as possible, as they are now former detainees and rejected by society. This project, in partnership with other institutions like the judiciary, the prosecutors, and social workers, and Secretary of State Penitentiary, is important because they will be at the end formally registered and appear as individuals exercising their rights. And the first thing that was done was to create a working group, an interinstitutional exchange with these institutions, like the ones I told before. We have a universe of around 52,000 detainees in Rio, and many of them have no identification. It must be said that there was a significant increase in the prison population, which in 2013 had 36,000 prisoners, and this year the number has reached 52,000 prisoners only in Rio. In Brazil, we have more than 700,000 prisoners, and we are the third largest prison population in the world. When the inmate enters the system, criminal identification is given to him or her, and this one is different from the civil identification. This number doesn't allow them to exercise their citizenship when they get released. The most obvious thing to be done would be to implement the identification at the entry ports of the system, but it just doesn't happen. So a schedule of actions was established with the aim to eradicate the lack of registration of the incarcerated people. For example, the survey of number of cases set a link between the working group and the other institutions to implement the elected actions, lectures and training for defenders, judges, and prosecutors, proposed elaboration of material on the importance of basic documentation, institutional video development addressing the importance of birth registration to be displayed at visitor registration centers, propose a schedule of interviews in the units by social workers, and so on. The most important project aim is to reach prisoners who don't have a civil identification to formally register them and reintegrate them to society in a country full of bureaucracy, rescuing their citizenship and ensuring the most basic human right to be identified and exist towards the state. Thousands of children live in the streets of Brazil, growing there. For the vast majority, this means the absence of an identity document. They do not formally exist. They are not accepted in health services. They cannot attend the school, cannot claim social benefits, or enroll in government programs. This problem usually lasts into adulthood, and these people only get out of bureaucratic invisibility by committing some offense. Their only legal record is the one where they play the piano. That's an expression that we use because they have to leave their fingerprints when they enter the system, when they are arrested. Without birth registration, you cannot obtain an ID, a voter's title, or a work permit. Some stories are really dramatic. They try to get back into civilian life, get a job, but they do not even get a document that identifies them as citizens. Unfortunately, the lack of a public policy to address these cases is real and clear. The exercise of the right to identity guarantees the right to nationality. The Inter-American Court of Human Rights, in a very important precedent in the Inter-American system, the Yan and Bozico girls versus Dominican Republic case, sets that without a civil birth register, a person remains stateless, and statelessness in turn precludes the enjoyment of civil and political rights of a person, causing a situation of extreme vulnerability. Also, the Serrano Cruz sisters versus El Salvador case states that the right to identity is closely linked to the right to recognition of legal personality, the right to have a name, a nationality, a family, and to maintain family relations. It's also foreseen in the American Declaration of the Rights and Duties of Man, the International Covenant on Civil and Political Rights, and the American Convention on Human Rights. An important international document produced by the Ibero-American countries, the 100 Rules of Brasilia, expressly names persons deprived of their liberty as persons in situation of vulnerability, since they face special difficulties in fully exercising their rights. In Brazilian law, the position of citizenship and the dignity of the human person are two of the foundations of republic. In order to ease the registration and issuance of IDs, the judiciary has begun conducting video conference hearings for this purpose, used before exclusively for criminal hearings, contributing to the safety, speed, and cost of the procedure. Only in 2015, a law was passed that determines the registration in the maternity itself, but two factors hinder. Not all poor women have their children in hospitals. Special strategies were defined, such as the organization of itinerant services to guarantee the right to birth certificates and basic documentation, especially in the various specific population groups like indigenous people, gypsies, quilombolas, street people, rural workers, collectors of recycled material, and people with difficulty accessing the offices and bodies issuing basic documents. Thus, a questionnaire was developed for the interviews in prison units, where information is collected on whether they have contact with family members, personal life history is asked, name of parents, whether they were in an orphanage, where they were born, if they were baptized, got to study in some college, if already voted in elections, if already served to the military, and so on. In this way, booklets are being prepared to be distributed to the relatives of the prisoners assisted by the Public Defender's Office, and also for health service agents to raise awareness about the importance of the civil registry. It's not uncommon for us to assist people of advanced age whose children, grandchildren, and great-grandchildren do not have the record, enabling all those generations to have a birth certificate. The project participants were divided into 3 teams: the Public Defender's Office, the Judiciary, and the Penitentiary Secretary of State. During the visits, social workers from Defensoria will lead the prisoners' interviews using a standardized form, and after completing these forms, diligences will be made to obtain the documents. In case of need, the result of the diligences will lead to late registration access. And it's important to tell that Defensoria has, although we have more than 800 public defenders, we only have 8 social workers to do all this work. So it's going to take some time to get to the end of this project to reach our aim. Upon obtaining these documents, they will be delivered personally to the prisoners, or in case of freedom, they must be withdrawn by them at Patronato Margarino Torres, in the case of a prisoner who has been granted conditional release, or in the Criminal Institute Cândido Mendes, two institutions in Rio that deal with people that get released. The interview started 2 months ago, and we face some difficulties regarding the number of social workers, as I have just said, available to do the interviewing. Until now, more than 200 detainees have been interviewed, and among them we have found 51 without registration or IDs. With these actions, we can help these people to be reintegrated in society. Thank you for your attention.
Thank you very much for a very unique and interesting experience and sharing that experience. And Ms. Hadeel Abdel Aziz is going to present the experience from Jordan perspective. She is representing Justice Center for Legal Aid.
Hello everyone. Thank you for having me here, and thank you for attending. My name is Hadeel, and I'm the executive director of an NGO in Jordan that's providing legal aid, but also trying to create change and in order to create systems that are actually replicable, that hopefully will be adopted by the government of Jordan or by the Bar Association or any other organization that is willing to take on the projects and the cause of legal aid and make it sustainable. Part of what we do is we provide legal assistance in criminal cases. We have a criminal justice unit. And since our establishment 10 years ago, we would always receive cases for people who we were representing in criminal courts. We would get a lot of allegations of torture. Many people would say they have been either tortured or abused or mistreated in police stations. Most of them would be too scared to come forward and to submit a complaint. Many of them actually were not at all interested in doing that because they had no faith in the system. They were scared of retribution. On the other side, the government of Jordan has done really good work in trying to limit torture in detention centers, in rehabilitation centers. However, it continued to exist, and the problem continued to be very much visible in police stations. The National Center for Human Rights has actually documented several cases and has documented that there was an increase in number of cases being reported where there has been some kind of mistreatment in police stations. On the other hand, it has always been denied, like this is not a systematic problem. It is an individual cases. So always the government would not accept any kind of recommendation to try to limit torture or to end torture because they did not even acknowledge that it was a systematic issue. Our proposal was that, okay, you do not have to acknowledge it as a torture issue, and this is not our fight. Having a lawyer in the police station would actually prevent torture without the government having to officially acknowledge that they are trying to stop torture. So our goal was to work on ensuring that everybody in Jordan was having at least the right to a lawyer. And there were different challenges. The first one of them was legislative. So our law, our criminal procedures law, does not guarantee the right to a lawyer. It does not forbid it, but it does not state it as a right. So our criminal procedures law says that every defendant will have a right to a lawyer as the prosecutor, but it does not mention the police. Also, it does not grant the right we don't have the Miranda right. So people don't know what they are charged with, and they do not know, they are not informed of any right of counsel. On the other hand, there's also institutional resistance. It's not just legislative, but also the police in general always thought that it was not the place, or there was nothing that a lawyer should be doing in a police station. So it was very interesting when talking to you and hearing for the last 2 days. Feels, it's so natural. I don't even have to preach to the choir. We don't have to argue on what is basic, right? It is not very basic. It's not basic at all. In fact, the right that is ignored for such a long time, it becomes contested. It's almost as if it's not existing. Another thing is there's the culture. Because of decades of not having lawyers in police stations, people actually did not even think to call a lawyer if they were asked to go to a police station. So it was a culture. Studies showed that 99% of people were not represented in police stations. 99%, which means that not only the poor, in general, people were not using lawyers or not asking for the services of lawyers when they are arrested at police stations. Another thing is that the culture among lawyers themselves, many of them would say, why would I go to the police station? There's nothing that I could do. Because, again, decades of malpractice meant that they could be themselves either threatened or they are mistreated or at least insulted. Many lawyers think that it's humiliating to go to the police station, so they refused. So this was a pilot to create change. It was important to deliver the services. But the whole idea is that by delivering services, you are trying to create cultural change without changing the law. So the first thing we did was we analyzed the law, the existing law. It was obvious. I mean, we are advocating to change the law for 10 years now. And this year we had a really important amendment to the criminal procedures law. We pushed for amendments so that the Article 99 in the law would be amended and the right to access to a lawyer would be mandated. We were not successful. So our option was, let us use the existing framework. We analyzed the legislative framework that's currently happening in Jordan, and we found out, although that the law does not mandate representation by a lawyer at the police station, it does not it doesn't say that you do not have the right. So this means that it is a general rule that all criminal laws should be interpreted to the best interest of the defendant, because unless it is prohibited, then it is allowed. If it's not prohibited, then it is allowed. Another thing is, so what we did is we actually conducted a program where we have retained the services of lawyers and we operated a hotline. The first thing that we did, there was one thing that I did not mention, that the Jordan Bar Association's law gives the right to the attorney to represent their clients in the police stations. Yet, it was not acknowledged, it was not implemented, because many times the police would say, no, this is not our law, this is the lawyer's law. We selected lawyers by conducting generic trainings on general fair trial standards, access to pretrial representation, and then from the lawyers we trained, we actually got shortlisting and applied, and then we contracted several lawyers who were then trained with a special training. One of the trainings that we give is to train the lawyers what to do if you are denied access to your client, what to do when they will not allow you. I apologize. Yes, thank you very much. Thank you. What to do if you go into a police station and then they say you can't see your client. Our training says don't even talk to them. Talk to the head of the police station. If you're not successful, then you go to the directorate, to the police directorate. And then you submit a complaint to the police. We have a unit that's called Transparency and Human Rights within the police, the PST. So you actually submit a complaint. If by then you are not successful, then surely your client has been tortured. So you go ahead and you start a process of sending notice to the prosecutor that you suspect there has been a torture case. The only time they will be so adamant of not allowing a lawyer to see the client is when something is wrong. So this was part of our training it was an escalating steps. And every single lawyer got that manual of what to do and what to do next. And it was a very interesting project. Part of the things that we had to do was to ensure that we had procedures in place. We could not do it ad hoc, so we had a manual for lawyers, manual for people who were managing the hotline, training for the hotline officers on even what kind of information to give, what kind of questions to ask, how to do referrals, what to do if there was a selection process for lawyers based on geography, based on timelines. We had every lawyer would register where they wanted to serve and what hours, and if they wanted to shift their hours, they would actually call the hotline officer. Of course, then there was identification of cases based on complexity. We identified complexity factors, and that was also, again, something that's very much homegrown. We had no system where we could copy from, because it had to be relatively not expensive, and it had to be simple. We could not afford a very complex data system, so it was done by Excel sheets that were locked with formulas. All the data was kept, and we were actually tracking durations and timelines because we wanted to see how much it would take a lawyer to get to the client, because this was very important, because one of the things that the police was claiming, having a lawyer would delay the investigation. Having a lawyer would be actually something that we have to resist. They did not trust the process. So we wanted to show them that it can indeed be efficient. This is an example of, if you would, thank you. So this is an example of our procedure manuals. It just shows like a simple thing. So it goes to the hotline officer, and then there were questions that they are trained to ask. Based on that, if it's simple enough, then maybe information can be given on the phone. If not, then it has to be referred to a lawyer, a duty lawyer. And after 2 hours, they would have to call back to ensure that the information that they gave was sufficient to solve the problem. Because after 2 hours, things could go wrong. So we would actually then re-refer it to a lawyer. We had a problem with outreach because we were too scared to just go online, and we were worried that we will get like thousands of cases where we could not handle. It was just a pilot project to begin with. So we actually started by giving the number only. We put it on our website and then started to give it to our partners, 79 referral partners. Many of them are actually working with Syrian refugees. So you would see that the nationality of the people we are serving are, like, interestingly, the highest nationality was Syrian, then Jordanian, and then Sudanese refugees. And that had to do with our outreach. We believe that once our second phase starts and we go just national, Jordanians will be definitely the highest rate, the highest population that we're serving. Outcome of the service, so we were successful in achieving release only in 36% of the cases. 55%, nothing happened. They actually continued to be detained. But still, our training to the lawyers that it is not your role. You're not there to release them only. This is not our sole objective. Our sole objective is, number one, they know they are not tortured. Number two, they do not confess to a crime that they do not understand or they have not committed. And number three is to observe the detention periods, because the Jordanian law only gives 24 hours to the police, and then the person has to be referred to a prosecutor. In many cases, that duration was not observed by the police. Also, you see here there's an execution completed, which means that this was a debt. They were arrested because they were in debt. it was an execution case, a civil execution case. Unfortunately, the Jordanian law still allows for imprisonment of debtors. As I said, we had a problem in our outreach, and this is something that we think we would like to think that we're solving now, and we expect that next month we're going to start advertising our hotline number more and more, which would probably put a lot of pressure on our resources, but we believe it's about time we do that. The outcomes of the pilot are always constantly documented, and then they are shared with our partner, the Public Security Directorate. One of the things that we noticed that people were always detained, the 24-hour period was never observed, and the way to work around it was they would actually move the detainee from one station to the other. So what we did in our hotline, and because we have a network of lawyers in more than one city, what we do is we would chase them, follow them, like if they're moved from one police station to another directorate, or sometimes to a directorate in another governorate. Our lawyers from the other governorate would be following them, which meant that in many cases this strategy became useless. So hopefully this again will help change culture and limit these practices. Interestingly, like when we started, we thought like the torture is so predominant. It's a very major issue. I still believe it is a major issue, because what we found out that 3% of the people who use the hotline have actually reported abuse or mistreated. 3% is a lot, but it is not as major as we had thought it is. Sometimes the stories of things that go wrong are much bigger than the actual problem. So in fact, this is good because it can actually tell the government of Jordan, this is a simpler case than you think, and you can work on it and you can solve it. Other things that had to do with unification of procedures. So it was totally ad hoc. One police station would actually accept lawyers, the other would give them more trouble. But interestingly, as we went along, every single one of them became more receptive and more cooperative. In fact, my colleagues told me that now one police station is actually calling us in cases that were, in their opinion, simple enough. Okay. Our number one, and that's the takeaway of this pilot, culture can be changed. It is sometimes easier than we think, because we always think that the easy way is an up-down approach. Not really. Sometimes if we can't change the law, we can work within the existing legal framework and change and protect people. Thank you.
Thank you very much. It was very impressive, and I guess that you must be proud to be part of this changing the culture. So yeah, thank you very much. And now let me introduce Ms. Natalie Rea, President of Court Access Program, and she will share experience about the app, which goes to Fofo. The microphone is not.
Thank you for actually still being here, and I'm really happy to introduce for the first time the Court Access Project, which is a very new NGO. We've presented it at different private meetings in New York, and you're the first public rollout of this project. The sole purpose of the project is to eliminate delays between arrest and first court appearance using technology. SDG 16 recognizes the problem of global pretrial detention. Somebody mentioned we separate that into post-charge, pre-charge. We go a little further, and we take pre-charge as pre-first court appearance and post-first court appearance. The key, in our view, to limiting the problems and the abuses, both before, certainly, let me go back. Every statute, every country in the world provides for a timeline for the first court appearance. It is key for any prosecution to have that timely judicial oversight. It's important for torture reasons. If a person is detained and must be presented to a court within 24 hours, and that person is not going to be, if that person is presented in court, they will not be tortured, at least not in a way that can be apparent. So, I mean, some of you, it may come as a surprise that there are people, primarily the poor, who find themselves detained and essentially forgotten in detention centers for not only days, months, but years. I have been called once working in a country by a judge who had identified and found 40 detainees who had been there for 4 years and never seen a judge. So it is a problem. But it doesn't have today, in 2018, it doesn't have to exist anymore. And I'm not the greatest tech fan, may I say. But yes, the answer, as everything is today, is an app. And so let me introduce you to the Court Access app. It is simple, it is cheap, it is user-friendly. I'm going to describe what it's going to do, and then I will show you the show. The idea is that police officers will download into their phones or be provided with phones with this system. They, at the time of arrest, they will input the name of the suspect right there on the street. The app, as you know, with its GPS capacities, will auto-populate the information of the place of arrest and the time of arrest. And because every country has a timeline, maybe 24 hours, 48 hours, 72 hours, whatever it may be, before you appear before a judge, the app will calculate that. So if you're arrested today, November 15th, the app will calculate that you must appear by November 17th. That information will be shown on the phone of the police officer to the suspect. The suspect is its best lawyer as far as that goes. Once the suspect has that information, by November 18, he or she is going to say, sorry, I was supposed to be in court yesterday. Okay? And that's it. They're not going to stay in for 4 years. The officer just then submits. You know that button, submit. And that information will go to the court. And it will notify the court and place on the calendar for November 17th the name of that person. So the court calendar will see arrest of Mr. X or Ms. X. You can click, and the information that was entered by the police officer will appear. It can be information if you have, and I'll show you, if you have a barcoded ID somewhere, the app will simply scan the ID. You can take a photo if that's what that jurisdiction requires. So now, introducing for the first time in Georgia, the Court Access app. Here it is. So this is how it works. It's not YouTube, huh? Don't expect. This is simply to show that most countries in the world have a time frame. It is it's very rare even to have the language prompt appearance. I mean, that's the exception. The police officer downloads, presses the icon as you do for Facebook, and then he signs in as you do for your Facebook and Instagram or whatever. I want you to see that it's in Georgian also. This is for our hosts. Thank you very much. Okay, and this provides this could be assigned ahead of time. So if you have a barcoded ID, you would press barcoded ID and just scan. If not, you press enter info. And this is the information you enter, right? So you put the person's name. It can be different identifications per jurisdiction. Like I'm thinking of Afghanistan, probably you would have the father's name as ID. So that really depends on what is required in the jurisdiction. As you can see, you can enter gender if you want. The location is just simply that you don't have to do anything about that. Don't do anything about the time. And then you can have a photograph, and I'm sure most of you may recognize Charlie Chaplin. Once you confirm that, the screen to the right is what appears on the person, on the cop's phone, on the police officer's phone. He shows it to the suspect, and this is the information the suspect will remember. At the top, you can see his name and the date of his court appearance, which is key. That's all the information we need. Okay? And this is what the court receives. It's a little small, but you can see it says today's arrests. So the court will have that auto-populating its calendar. So if it's with a court clerk, generally, I mean, in most jurisdictions, there's a court clerk that will go from there to place it on a specific judge's calendar. And then the court will say, if that person doesn't show, where is Mr. X? And this is what makes the difference. The court now knows this person's been arrested. This person cannot be lost in the system. It's not possible. So we have a backup, which is that some people suspect that maybe police officers, and we can discuss it, will not use the app. I don't believe that, but I think that we can all agree that apps have changed our conduct in many ways. We do many things, and I think it can also change the conduct of police officers at the time of arrest. If, however, the police van arrives at the detention center with 5 guys in it, let's assume they're men, and there's only 4 people are it will have received all the information. Only 4 people are listed. The detention center can also enter the same information, and the court will be notified, but it will show that it's arriving from the detention center and not from the arrest place. Okay, if I go back, on the right, there's a link there for the court. If the court clicks on the link there, it sees the same information that was entered by the cop, by the police officer. Okay, so that is the overall, that's pretty much the presentation. Obviously, this can have a lot of consequences for early access by a lawyer. The point of the app is timely judicial oversight, getting the courts involved when they're supposed to get involved. Because I think that one of the big problems of these delays is, first of all, lack of communication between police, detention centers, and courts. Also, the understanding the police officer thinks his job is to arrest, not really to appear for the arrestee to arrive in court on time. The detention center's job is to detain, again, not to bring the guy in on time. But so we need the courts to step in when the legislature told them they needed to step in. It wasn't for nothing. And we've accepted things like, oh, the van is broken, there's no gas, there are a million reasons why this doesn't happen. But the information that one can gather with the app, without being the threat of big data, can show you can show some trends. You need to go to court 5 times a week. You can decide what kind of gas you need. And so the ministerial things that this can help with are not minor. So we are here. We are very happy that you've heard this for the first time. And we're looking to start a pilot project with an impact study in May. We're happy to have a country here that has expressed its interest in having us. And if you think your jurisdiction would like to try this because you think there is a problem, you can go to our website. It says pilots, and you can sign in. And we're picking jurisdictions where we think, of course, it will work very well. But maybe we should pick one where we think it's not going to work at all. So we'll leave it up to you. So thank you very much for your time.
Thank you very much. Yeah. And Ms. Suzanne Lee, Access to Justice Advisor representing British Council. Yes, for sure. Yes.
I really want to thank so much the conference organizers as well as our Georgian hosts for what has been, I think, a very thought-provoking and very interesting 3 days of this conference. And just so you know, I'm a former public defender from New York as well, and there's nothing as inspiring as hearing from people like my fellow panelists about the great work that they're doing and the good fight that they're still continuing to fight. I am the Access to Justice Advisor for the My Justice program in Myanmar. My Justice is a 4-year access to justice program funded by the European Union and implemented by the British Council. We take a very grassroots-up approach. We work with local civil society organizations to ensure communities better understand their rights and how to claim them. We work to ensure justice services, whether they're provided by the government or civil society, are more effective and more responsive to people's needs, and with a special focus on strengthening criminal defense for the indigent accused. We also work outside of the formal system. We work to make community-based dispute resolution mechanisms more fair, inclusive, and accountable, because most people in Myanmar seek to resolve even criminal disputes outside of the formal system. And finally, we conduct research and share lessons learned to inform justice sector policy and implementation. And while we don't have enough time today for a deep dive, it is essential to have some understanding of Myanmar's context for my presentation today. It is enormously complex. And I will ask the forgiveness of all of my colleagues here from Myanmar for oversimplifying what is a very complicated history. Myanmar is transitioning out of 6 decades of military rule and is moving rapidly towards a civilian-led government. Rapid changes have been underway not only in the political realm, but also economically, socially, and technologically. This history has left an indelible mark on the relationship between the state and its people. And research conducted by My Justice shows that the public perceives the law as an instrument of control and oppression, rather than as a source of rights and protection. And while most ordinary people understand basic concepts of justice, people do not associate justice with law. And public trust across all government institutions is low, but unfortunately it is lowest amongst the justice sector institutions. Now, there are many opportunities amidst all of this change, and one is the rapid adoption of new technologies. Now, 5 years ago when I arrived in Myanmar, mobile penetration was only at 7%, and a SIM card cost me $200 US. Today, mobile penetration is at 90%. SIM cards cost less than $1, and it's estimated that 85% of the people who own mobile phones use a smartphone, which is much, much higher than the country where I'm from, the United States. So suddenly, we have millions of people who never accessed the internet before, who have powerful computers in their hands, capable of delivering extraordinary amounts of content and presenting a unique opportunity to democratize access to information. So we asked, can we use this opportunity to begin to rebuild public understanding of the relationship between law and justice, between the state and society, between duty bearers and justice seekers? So we collaborated with a local Myanmar tech company called Coco Tech to develop what we call the Lanpia Access to Justice mobile app. Lanpia means show the way in Myanmar language, and that's what this app is all about. We aim to inform people about their rights, connect justice seekers to the people who can help them, and to empower ordinary people to take steps towards claiming their rights. So Lanpia contains extensive, easy-to-understand, know-your-rights content, especially on the rights of the criminally accused, as well as rights relating to land, labor, women, children, LGBT people, as well as how to access civil documentation, which is also a very, very big challenge in Myanmar. It also contains a glossary of terms for non-lawyers and non-legally educated people, and links through the legal aid Know Your Rights contact to Myanmar laws. There is also a news feed, which you'll see scrolling through here, similar to what you'd see in Facebook, but rather than seeing photos of your friends' children and their pets, it contains rights-related content drawn from research in Myanmar, drawn from the Know Your Rights content, drawn from civil society organizations, news from the justice sector institutions, as well as inspirational stories of ordinary people and civil society actors, legal aid providers, seeking justice and achieving success. There are also quizzes that the users can use to test their knowledge, and links to external resources provided by the government and by civil society. We will be translating all of the Know Your Rights content to at least 3 of the many, many ethnic minority languages used in Myanmar. And next, there is what we are calling How May I Help You? But what it is a chatbot. So for anyone who is technologically savvy, you'll have a sense of what that is. I'm not technologically savvy, so. But it's basically an automated guide that guides the user through a series of questions to determine what kind of information and next steps is appropriate for that user. So it's based on what we know from our research are the most common problems and commonly asked questions in Myanmar. So that's what happens when I get arrested, what do I do? It has to do with how do I register my land? How do I file a claim for land that has been taken away from me? How do I get civil documentation? Things like that. So for example, a person who indicates that someone has been arrested by the police will receive the most relevant information, namely that they have a right to a lawyer from the time of their arrest, their right to remain silent and not to be forced into a confession, and it prompts the user to contact local legal aid organizations and lawyers. The bot also provides step-by-step information about what comes next in the case, and especially on non-criminal matters, step-by-step instructions, for example, on how to register one's land or file a claim in an employment dispute. Of course, this bot is not intended to substitute for competent counsel from a lawyer, but by walking people through different rights and the processes that they will be facing in a particular situation, we hope that it gives people more confidence to engage and to advocate for the protection of their own rights. Now, people in Myanmar also generally don't understand that it is the role of the lawyers to protect clients' rights. So we also provide what we are calling an FAQ, or frequently asked questions, that act to empower clients and empower clients in their engagement with lawyers. It also, we hope, will serve as a bit of a check on the lawyer's behavior when the clients actually know what their rights are and what the lawyers are supposed to be doing. They are able to actually check their own lawyers. As Rick Jones said earlier today, client first, client last, client always, and we really hope this helps to set some of those expectations in attorney-client relationships in Myanmar. The app also contains directories of lawyers, which are searchable by location, specialization, and whether they provide pro bono or legal aid services. And we are very grateful for the support of bar associations, including the president of the Independent Lawyers Association of Myanmar, in helping to get lawyers to sign up and include their profiles in this directory. The app provides directories of civil society organizations who provide a constellation of services that clients need, not only legal aid, but drug rehabilitation services, land advocacy help, victim support, psychosocial services, microfinancing, and other services relevant to breaking the cycle of poverty and incarceration. So, and finally, thanks to the cooperation of government institutions, the app will also provide, for the very first time in Myanmar, a nationwide digital directory of the courts, law offices, which are the prosecution services, and police stations. And all directory listings will include phone numbers that you can call straight through the app. Now, the app is not yet in use. It launches in 2 weeks. And over the next year, we will be working to monitor how people are using the app to better understand what kinds of adaptations are needed, what are the most useful types of content, what are the types of information that people are most likely to read and to share, who is being called through the app, and we will keep returning to the drawing board to redesign to make it more useful for people in need of services. We will be promoting the app widely to the general public, but also disseminating it in a much more targeted way to the service providers, the frontline providers, the intermediaries. That includes people from the government and civil society, including local administrators, which is where most people in Myanmar go when they have a justice-related issue, legal aid providers, and hopefully through a partnership with the Union Legal Aid Board, community-based paralegals, civil society organizations, and of course from other sectors. It's very important to build these partnerships and understanding. We want to reach out to community health workers, librarians, educators, other frontline providers of services who work at the grassroots, and while many of them may not be lawyers or otherwise legally related, they are the de facto advisors and paralegals by virtue of their positions of trust within the community. Now, we are under no illusion that this app, a single app, will address all of the challenges that Myanmar faces. And generally, I'm pretty skeptical of technology as well, and especially skeptical of apps. But we do hope that through our outreach and the use of the app, governmental and non-governmental services, service providers will be better connected to each other, and that referral networks and trust will be strengthened between them. And we also hope that by putting the law into people's hands in this way, with concrete step-by-step guides to what it means and what can be done, we can begin to empower people to take back the law as a tool for protection and to aid their fight to change their own lives for their better. So thank you so much for your time, and please take note of our Facebook page. If you like the Facebook page or follow it, you'll be updated with information as the app launches and when we learn more about what's happening with it. So thank you so much again.
Thank you very much. Very interesting experience, and we all have maybe I'm sorry? Yeah, go ahead. Yeah, so the question would be how to reach out to people. So I was thinking in parallel, what would be the challenge for that app? So that looks very interesting. It might be very effective. The only thing, the first step is you have definitely the plan how to reach out people. So more and more people are engaged to download the app and then use it. And Mr. Ivan Honcharuk will share from UNDP, Ukraine, additional experience about the app and using the app effectively in our services.
Good day, colleagues. And after Susan's presentation, I can say that we have the same, but a bit less, actually. Now, I work for the Recovery and Peace Building Program UNDP Ukraine, and one of the priorities of our activities is to ensure and improve access to justice for local population, and most of all for the vulnerable groups, including those affected by the conflict in the east of Ukraine, first of all in Luhansk and Donetsk region. People need to normalize their lives, which obviously is impossible without the restoration and protection of their rights and accordingly legal support. The constant need to contact governmental authorities forms the need not only to inform people about the realizations of their rights, but also about the existence of such rights. Now, according to the data from the State Border Service of Ukraine, about 4.5 million persons crossed the line of contact in the government-controlled area just during the current year. The latest research of the NGO The Right to Protection shows that intention of about 80% of these people is to address certain legal issues. Just during the current year, more than 14,000 court decisions were made in both Luhansk and Donetsk region regarding the establishment of the facts of birth and death in the non-government controlled area. In other words, people require knowledge on how to realize their rights. Another example is the number of cases of issuance and extension of restrictive prescription, a document that can be issued by a court in the frames of civil proceedings in case of domestic violence. This document identifies one or more measures to temporarily restrict the rights of the offender or impose certain legal obligations on him or her. According to the United Nations Population Fund There are about 1.1 million cases of domestic violence that occur in Ukraine annually. At the same time, less than 85,000 of such cases are reported to the police. However, for 1 year, only 70 cases of restrictive prescriptions issuance have been considered by the courts throughout Ukraine, including 1 case in Luhansk region and none in Donetsk. This shows that people do not know their rights nor the ways to how to realize them. So, how can people get respective information and advice? We try to solve this issue somewhat with a somewhat innovative approach and realize that the best way is to put such an advisory service, if you may call it, in each and every pocket. The mobile application called Your Right became such an advisor. At the moment, the application consists of 3 sections: legal rights of the internally displaced persons, legal rights of survivors of gender-based violence, and advices for implementation of legal rights of these categories in the court. The application does not need an online access to operate. Each section brings together the most urgent questions for each category of persons, united thematically. If different topics overlap, for example, a person needs to register at the employment center and to get the IDP status, the application contains internal links to the respective sections. In addition, the application contains explanations of unclear legal terms, contacts of state and non-governmental organizations that can provide free of charge legal aids, functions of respective state authorities, requirements for procedural documents, rights and obligations of parties during the court proceedings, and rules of conduct in court. All legal advices are provided in non-legal language, which, however, are in accordance with the current legislation. There are also links to the relevant legislative acts. The advices are made in this question and answer form. They provide a step-by-step action plan for solving a particular legal issue. Particular attention deserves a section devoted to the protection of rights in court. The UNDP study shows that the people's attitude to the court depends on their experience in the court. The more experience, the better the attitude. Therefore, we try to reflect the whole trial from the perspective of the applicant or plaintiff. Of course, such a description cannot replace personal experience, but it gives a general idea of what exactly awaits a person in the court, thus destroying a negative and at times stereotypical perception of work of these institutions. And here we placed a QR code in case you want to try it, but of course it's in Ukrainian, so I don't think you understand anything. Thank you very much.